Happy New Year. This is our first Facebook Live back in 2022. And today we are going to be talking about divorce and finances. As many of you know, the first Monday in January sadly is dubbed Divorce Day. And sadly there'll be a lot of people watching today who this may be relevant to. So I thought we would kick off now and introduce you to my guest. So, as I've said, divorce can be an incredibly stressful time for both you and your partner. The whole process can leave you feeling emotionally drained, burnt out and anxious. And there's so much to consider. Finances are obviously one area that can be difficult and sensitive to navigate. So understanding some of the basics of how finances are divided up during the divorce can help you to reduce these feelings and help you feel more in control going into the process. So that's why I'm delighted today to welcome Neil Russell. Neil is a family lawyer and partner at Seddons LLP, and he's going to take us through the options that are available and how best to get prepared for when you and your partner are dividing finances during the divorce process. So I'm just going to welcome Neil. Hi, Neil. Thank you so much for coming in today.
Thank you for having me back. It's a pleasure to be part of your wonderful group.
Thank you, Neil. Now, for those that don't know, Neil and I actually did another Facebook Live. I think it was this time last year, actually, and that was much more about the divorce process and what to expect. And you can find that on our website and rewatch the video at any time to suit. But as I said, today we're going to be diving in a lot deeper into looking at the financial circumstances. So before we chat, Neil, I want to quickly introduce people to you. So Neil is, as I said, a partner at Seddons, and he advises on all aspects of relationship breakdown, including divorce, children and finances. His clients come from all walks of life, from stay-at-home parents to captains of industry, high-profile celebrities and owners of family businesses. And it is actually a matter of public record that he also acted for the Prime Minister, Boris Johnson, on his divorce. Neil has been described in Legal 500 as one of the go-to men in the London matrimonial world, and he's also a family law commentator and regularly appears on LBC Radio on the Family Legal Hour. So Neil, before we talk about finances, there is a little bit of good news this year, isn't there, in terms of the change in the law with this new no-fault divorce. Maybe before we talk about finances, can you just briefly explain about that, what it means to people who are going through a divorce either now or in the future?
Yeah, well, what it is that at the moment, when you want to get divorced, you get divorced on the sole ground that the marriage has irretrievably broken down. And that's proved by one of 5 facts: adultery, unreasonable behavior, 2 years separation with consent, 2 years desertion, or 5 years living apart. And so if you haven't got the separation periods, there is effectively a fault-based requirement. Either someone has committed adultery or someone's behavior is unreasonable, because not everybody has lived apart for 2 years. And there's been much concern about this. And finally, we have the Divorce, Dissolution and Separation Act 2020, which was due to come into effect in autumn of last year, 21, but it was delayed because it is said because the IT systems at the court weren't ready to deal with the new procedures. And as of 6th of April this year, 2022, we will now have no fault divorce, which will mean the parties either jointly will apply to the court on the basis that the marriage is broken down, or one party only will apply to the court saying the marriage is irretrievably broken down. There will not any longer be a requirement to explain the reason for the divorce. So establishing a fact will no longer be a requirement, which is for many people very important, very important. Now, there are also, because many people who are listening, and either later on the record or now, are going to be thinking, if I want to start now, do I need to wait? Should I wait? Or should I just kick off? And my advice is every case is going to depend on its own merits. Some people will have genuine reasons not to wait because they won't otherwise be able to deal with their finances. There may be a requirement to kick off because it's going to prejudice their position to wait. So we need to look at each case.
Yeah, sure. And I guess the whole point of today's discussion is to try and help relieve some stress and worry. So I think that will go some ways to, you know, having one less thing to worry about in terms of having to sort of claim a reason. But look, let's sort of dive into the nuts and bolts of what today's discussion is about. And my first question for you is, what do people need to consider when it comes to the separation and the division of finances when they're applying for a divorce?
Right. The first thing I want to say is, if you are going through a divorce, you should not simply proceed to get your what is now a decree absolute, and under the Divorce Dissolution Separation Act it will be a final order. You don't want your divorce to be finished until you've got your finances sorted, because there can be a lot of prejudice created by not sorting out the finances at the same time as a divorce. Now, in terms of the finances, you need to consider what's going to happen to any property that you own, your family home and or any other properties, any savings, any investments, any pensions, shares in companies that are family businesses. All of those issues need to be considered because all of those have to be divided up and shared. Mm-hmm. So that's the sort of the checklist: property, savings, investments, pensions, family companies. Those are things that we need to consider to begin with.
And if you can agree on how to divide the money and the property, then what route would they go down next?
Well, firstly, I and most other lawyers will always encourage parties to agree the finances, because if you can agree the finances, then you save a lot of money on the lawyers, you save a lot of emotional expense. And it can be very emotional and very difficult to deal with. So it's much better to try and reach an agreement sooner rather than later. Mm-hmm. If you can't agree, then you can try mediation. We can talk about that further or now. But mediation is another way of trying to structure a settlement. But what you need to do if you reach an agreement is have it recorded in a court order. So there's a full and final settlement, even dealing with the ongoing maintenance. You need to have it approved by the court.
Right. And just very quickly, can you just talk about mediation? What would that involve? Yeah.
Can I just add, before I answer the question about mediation, in order to deal with a financial settlement, and we'll come on to that after, we have to deal with proper financial disclosure, because a party should never agree a settlement unless they know what the assets are. In very simple cases, it may be very easy to know what the assets are, but some cases are more tricky and there's further inquiry as to what those assets are. And that's dealt with in a court prescribed financial statement called a Form E. And I think we're going to talk about that after, Katie.
Yeah.
But in the meantime, you need the financial disclosure first. Coming back to your question about mediation, a mediator is someone who is effectively appointed by both parties to help facilitate a negotiated settlement. Mm-hmm. That mediator is not there to advise either the husband or the wife in terms of what the outcome should be for either of them, but is helping to facilitate what would be the right kind of outcome for both of them. Now, that mediator will generally require the parties to provide their financial disclosure. And then the mediator will be in a position to help the parties reach a financial settlement. Now, many people are very worried about how this process works. Some people say they don't want to see their partner, they don't want to be alone in the process. So let me just take a moment to explain that. Typically, the mediator will have an initial conversation with I'm going to call for convenience husband and wife. We'll have a conversation with the husband and a conversation with the wife, suggest that both parties put together their financial disclosure, and then they should have a joint session. In this electronic world of Zoom, it is quite often on Zoom, so you're not in the same place. Otherwise, if you are at the same building, because it's in real time rather than on Zoom, then you can be in separate rooms. The mediator often wants to engage you both, but where people don't feel comfortable being engaged together, you don't have to be engaged together. The other point I want to say is you can still have your solicitor helping you prepare your Form E because you want to get that document right. You can and you shouldn't agree anything, and the mediator won't encourage you to agree anything until you've got a solicitor. Now, some of our listeners today, or those that watch it later on when it's pre-recorded, is they won't be able to afford a solicitor, and therefore the advice and assistance they can get from a solicitor is limited. But the mediator will generally help facilitate an outcome which is likely to be agreed by the court. They can't finesse everything, but they can certainly help the parties get to a better place. And the other thing is there's one person, the mediator, not two, which means the cost and the hourly rate will be shared between the parties. And it's typical for both parties to share the cost of the mediator, pay half each.
So when should the financial remedy proceedings be issued? And obviously, what do they entail? Are there certain sort of steps and stages you have to go through?
So when should they be issued? They should be issued if you can't reach a settlement, if one party is not willing to provide full financial disclosure. Also, if you need interim financial support, because sometimes, for example, one party is dependent on the other. So a husband might be dependent on the wife, or the wife is dependent on the husband, and they withdraw financial support. And then there's no interim financial support, in which case you need to run off and issue court proceedings so that you can get interim support pending a final outcome. Now, so why would we issue proceedings? So one, because we need interim financial support. Two, because communications have broken down. Perhaps mediation hasn't worked. Three, one party isn't providing full financial disclosure. And fourthly, maybe because there's a risk that if you don't get proceedings issued quickly, the other party will start trying to get rid of or offloading assets, and they'll try and put them beyond your reach. So you need to move very quickly. Once the process is started, and I should add, one of the requirements to issue an application to the court for a financial remedy application is that you have at least tried mediation. And that can be simply one person speaking to a mediator, listening about the purposes of mediation, and then saying it's not for me for whatever reasons, and the mediator will then provide what is known as a MIAM certificate, Mediation Information Assessment Meeting Certificate. That needs to be signed by the mediator unless exceptions apply in order to make your application to the court to deal with the financial remedy application. Let me explain briefly the financial remedy application then. So the application is issued and you're seeking all sorts of financial remedies: property adjustment, maintenance, child maintenance, pension sharing. Pensions are a really important asset that people shouldn't forget about. So the application is issued, filed with the court, and this is all done online these days. The court will then issue a date for a first appointment. That date is generally listed 12 to 16 weeks after the application has been applied for. The parties then have a court-issued timetable that says this is how you now prepare for the first appointment. And one of the requirements, if it has been done already, then it will need to be updated, but the standard directions from the court are that 35 days before the hearing, you exchange your financial disclosure in the Form E. And those who are thinking, what is the Form E? As you and I, Katie, have discussed, we're going to show them a Form E very shortly. But you exchange Forms E, and then once Forms E are exchanged 35 days before, 14 days before the hearing, the parties then file what's known as a schedule of issues, so identifying what the issues between the parties are, a chronology setting out a summary of the key dates, and importantly, a questionnaire. So that's what further information or documentation is required, because the Form E hasn't filled in all the information. For example, there's missing bank statements, or there's further questions that arise from the bank statements. And there might be valuations that are required for property, where property valuations can't be agreed, for companies, you know, like the family business. And you then rock up at court for the first appointment, which is really just the court's opportunity to manage the process and set out what needs to be required to get to the second hearing, hearing number 2, which is called a financial dispute resolution appointment. That's when the court, instead of a mediator, effectively a court mediation, a judge will help the parties try and negotiate and settle. Hearing number 2, financial dispute resolution appointment. By this point, any questionnaires that the parties have answered have been dealt with, and all the information is available now for the court to give a guidance as to the settlement. So typically a financial dispute resolution appointment, wife says she wants X and husband says, well, I'm only going to offer Y. And then the court says, wife, you're asking for too much. Husband, you're not offering enough. Go outside and see if you can negotiate a settlement and come back in. And if you can't settle, then you move on to the third and final hearing, which is where the judge hears evidence from both parties and decides what the financial settlement should be. Now, in some more complicated cases, there are other hearings along the way, but that was just a simple main 3 hearings which I've cantered through. And at each stage, the court will want to look at how much people's costs are, because bear in mind, where are these costs going to be paid for from? They're going to be paid for and from the assets available to be shared by the parties. Sure. So it's really important that we try and get things settled and resolved earlier. If a party is being difficult with their disclosure and they're not complying, then there may be cost orders made against them. Can I just go back very quickly? For the FDR hearing, the parties in advance set out their positions on a without prejudice basis. So the judge that's looking at the hearing, the FDR hearing, will not be involved in the later stages of the case. So you don't prejudice your position by saying, I'm willing to accept £500,000. Whereas if you went to a final hearing, you say, I want £750,000. So that judge who hears your without prejudice offer won't be involved in the case thereafter.
Okay. So let's talk about this Form E and why it's important. If you want to share your screen so we can kind of show everyone what they would...
Let's hope this works. Let's hope this works. Right. Okay. Can you see that now, Katie?
Yep. Yes, there we go. Yeah.
Right. This document is often really daunting for people, and they often have a mental block about doing it, preparing it. And there's 28 pages, so I've got to canter through, otherwise we'll be here a long time. But just so if I do canter through quickly, it's just to try and give people some insight as to the disclosure that they might have to provide or their spouse may have to provide, so that you can see that it's all put together. And this is a form that we all think generally gives a very good starting point as to the disclosure. So on the first page and the second page, it's just general information about the parties, so that we can see who the parties are, who the children are, the health that the parties are in, and just sort of general background and where the parties are living. We then get to section 2, and this is where we list the property that the parties have, and we start there with the family home. Generally, we need to have a value for the family home. Now, you may speak to the local agents to get an idea of value. You might put forward what you think is the right valuation. You put down details of the mortgage, and then costs of sale. Normally, we allow, when you're doing the Form E, 3% costs of sale, which is 1.5 to stroke 2% plus VAT for the agent's fees plus solicitors' fees. So it's a typical range that we initially apply of 3% costs of sale. And then you take that off the mortgage so you take the value, less the mortgage, less the cost of sale, and then you've got the net equity in the family home. I'll spend slightly more on this because nearly everyone's going to have a family home. Mm-hmm. And when it says who owns the property, details of who owns the property, quite often it's jointly owned. So you would put half of the equity is your share and they'd have the other half.
So it's literally, would it literally be 50-50 or
that's if the property is jointly owned. If it isn't jointly owned, then the argument would be that you should have at least half of the equity, but the starting point would be that the equity is in the other person's name because it's not in yours. We would often say, well, we should have half the equity as a minimum point. You then move on to details of any other property that you may own. Now, that may include investment properties. If they're owned outside companies, they're owned by you. If they're owned by companies, then they get allocated elsewhere. But quite often this may refer to a holiday home, but there might be a rental property. So you put those details there and the same principles apply. Mm-hmm. You then get to the next section, which is 2.3 bank statements. And what's really important to remember here, what it says, it's any bank or building society or national savings account that you have held or someone holds on your behalf or in which you have an interest. And you have to list each and every account, even if it's dormant. And you provide the bank statements for the last 12 months on each account. Now, some people say, well, the account's dormant, in which case there may not be an updating statement, but you might need to get confirmation that the account hasn't been used. The reason why the requirement is to provide statements for the last 12 months is so that it's not just a snapshot, because one page may show there's £1 million, but if you look back over the year, there might have been £10 million at the beginning. So where's the other 9 million gone? So we look at a year's worth of statements to get a pattern and see what's been in those statements. Now, sometimes you might be able to, in your questionnaire, go back more than a year, but the starting point on the Form E for the bank statements is a year. We then go down to 2.4, where you look at the other investments and savings that parties have. They might have shares in listed companies, they might have ISAs and trust interests. So you put the unit trust, the investments, and any other savings that aren't included in your bank statements in that section. The next bit at 2.5, policies. Quite often parties have endowment policies or what were endowment policies in order to insure against life and or to insure against life and then being able to pay off a mortgage. What you want to know, and you'll look in the bank statements to see if any of these policies are being paid, is whether or not they have a surrender value. Because some of these policies do have a surrender value, some of them don't. But if you disclose them, then we know whether they have a surrender value or not. Then you might be owed money, or the other person may be owed money. That's at 2.6. So you need to put details of any loans owed. Then 2.7 is always fun and games. Details of any sums held in cash of £500 or more. So if you have cash knocking around, then you need to say what it is, the amount. Now, the next bit is at 2.8, details of any personal belongings. When you're looking at jewellery and furniture and household contents, people often go to their insurance documentation. Remember, you don't want to get stuck with property that's valued by your insurers, because if you go and sell it, it's nowhere near that in value. One of the things I often say for household contents is put value not known, will get if it's required. because the household contents you're quite often going to divide between yourselves rather than value it or sell it. If there are important objets d'art or particularly valuable paintings and furniture, then you might need them valued, or you might be able to agree the values. And if they're substantial, then you probably will want to list them. Jewellery and watches, always be careful, because often people think that they're worth more than they are because that's what the valuation says. Be realistic. Simply because you've got a wedding ring for £5,000 doesn't mean you'll get £5,000 if you'll sell it, because it depends on the diamond and so on and so forth. Cars, have a look at the value, the realistic value of the car. Just add, for example, lots of people go to We Buy Any Car. Now, you find that they give great valuations and then you pitch up to sell it and you won't get that. So be realistic about your valuations. We then move on to liabilities and capital gains tax. If there are mortgages, they will be dealt with your properties, but any other loans, credit card debt, overdraft would normally be covered by your bank statements, but you might have a tax liability that you need to put down there. If you're going to sell a property because it's an investment property or a second home, there's going to be capital gains tax. Generally, in relation to the tax, we get an accountant to assist us, and the capital gains is set out in 2.10. So 2.9 is liabilities and 2.10 deals with the capital gains. I'm only going to skirt through very quickly. I'll skip through business assets and directorships at 2.11. Ordinarily, if you've got a business, you're better off getting your accountant to speak with your solicitor or to help you complete this section, because you're not going to understand it yourself. And I often say to my clients, I'd like to speak to your accountant to understand what we're going to put in here. You are required to provide the business accounts for the last 2 years, but they may not necessarily give a real idea of value. So I suggest that accountancy and help is required there. Directorships. If you've got a directorship beyond the family company, you need to list them all. You can go to Companies House and generally find a list of all the companies in which you have a directorship. Pensions, 2.13. Pensions take forever to get the information required. So as soon as you're ready, apply to all your pension companies for the information, and then they will generally be able to populate the information needed, or you'll do that from the information that they send to you. Other assets. Now that is really anything else that hasn't already been provided for. And in particular, it might mean trusts. You might be a beneficiary under a trust. You might be a defined beneficiary, in which case you know what you have. You might be a discretionary beneficiary, in which case you don't know what you've got. If any of those situations apply, then you really need legal advice, because you don't want to get that bit wrong. Then we deal with income. Now, income, very quickly, is not just what you earn by your P60 or what you take from the company, because there might be all other benefits that are received if it's a family business. There might be a lifestyle element to it. So if you're the person that's at home and the other person is running the business, providing all the expenses, you need to know what expenses have gone through the business as well. So that section needs to be looked at carefully. Self-employment income. Well, you'll generally have that populated from your tax returns, but you need to give the details there. And then separately too, that's dividend income, income from investments or rental income goes separately. And running through, and then there's income from any state benefits. There might be child benefit or the like. In case you're earning over £50,000, again, you need to check, because that might need to be repaid. You might be claiming child benefit and then find out each year you have to repay it with your tax. So I can only skirt through this quite quickly because we'll run out of time, and I know there's other questions. And then there's a sweep up catch-all provision for any other income. For example, some of our listeners may be in retirement age already. So then there's pension income that may be coming through, and that all has to be listed. So if there's income and it hasn't been listed elsewhere, it goes in there. And then if you're doing it on a electronic form. Section 2 is the summaries where it's all populated.
Yeah.
It's like a spreadsheet. It will add it all up for you. And if you're not using one of those forms, then you'll need to do it. Very quickly in section 3, this sets out your needs. Your needs comprise of income needs. So you're going to need to go through an expenditure schedule and set out all your expenses. That's going to include holidays, clothes, household bills, food, anything and everything. And you go through your bank statements, that will help give you guidance of what's needed. Also what's needed for the children. And then capital needs is housing. So we need to work out how much your housing costs are. And then other information is the information that the court is generally going to take into account when deciding what the distribution of assets should be on the breakdown of a marriage, which again, we're going to come to that in a moment and we'll run through that. That is, I hope, some indication of what the Form E requires.
Yeah, thank you, Neil. I mean, it's very, very detailed and long and complicated, and I'm sure for a lot of women watching this, if they're like me watching it, it could cause a lot of overwhelm. I'm assuming that if they can afford their own solicitor, that they will be handheld through this step by step.
Completely, but completely handheld. One of the things I should say, bear in mind, when you instruct a solicitor, you're paying. Their time is expensive. Hopefully they'll have someone less expensive to help with the process. But the more you can put together, the less money you will spend, because it will be easier for your solicitor.
Sure. Can we let's come off the form now?
Yes.
I mean, that obviously was really helpful. What I mean, in terms of, before we sort of talk about how, you know, financial settlement is agreed and how the contributions from each partner are taken into account, what I mean, in terms of children, are you able to come off share screen, or shall I take it off?
Now I can stop the share. That's not a problem.
Yeah.
Yeah.
In terms of children, obviously, you know, for a lot of women, their kids maybe are now either out at uni or living away from home, or not in education anymore. How does that kind of work in terms of child maintenance and what people are entitled to?
If the thing I always say to people, the easiest way to calculate child maintenance, if you have any idea of what your husband is earning, go onto the child maintenance service website, just type in child maintenance calculator, and you go on the government website and you put in what you think their gross income is, and it will calculate for you what the child maintenance should be. And there will be discounts for the number of nights that the children spend away with the other parent. So we start off with 7 nights, and then it'd be discounted 1/7, 2/7, 3/7, depending on the number of nights per week that the child spends with the parent. But roughly you're looking at a percentage starting out at around 9, 12 and 16%, depending on the number of children, of their gross income. In the old days, it used to be net income. Now the Child Support Agency calculates it with, it used to be calculated in relation to net income. The Child Maintenance Service now calculates it with reference to gross income. So got an idea of what he's earning, plug in the details, number of nights to be with you, and you'll get a calculation there for you. It's the easiest way of doing it.
Mm-hmm. And if they're not 100% sure, I mean, the reason I'm asking is we've just had a question in from one of our viewers who said, if my kids are all finishing full-time education, but he was the main breadwinner, what am I entitled to if my income was only a part-time job? I'm not sure of his income now because of COVID over the last 2 years, it's reduced. I mean, I just assume that each lawyer will speak to each other and get that information.
Yeah. The child maintenance is for children who are effectively in education or up to the age of 19. Yeah. When they go off to university, it's generally dealt with between the parents rather than the child maintenance service beyond 19. However, in the situation that you have just referred to, it sounds like the children are no longer in education, in which case she won't, the person who asked the question won't be entitled to any child maintenance. So their spousal maintenance may need to increase in order to provide for their needs. Mm-hmm. Because there's 2 elements of maintenance: spousal maintenance and child maintenance. Spousal is for yourself and child is for the children.
Sure. So that goes up to 8. Did you say 18 or 19?
Well, it varies because typically when the kids go off to university, you're going to be looking for maintenance whilst they're at university as well.
Yeah.
And then there's always the argument about whether it should be paid directly to the children or whether an element of it should be paid to the parent, because, you know, they've still got to keep a roof over their kids' head when they come home from university. And then the kids come home from university and they eat you out of house and home. So you still need the maintenance whilst they're at university as well.
Sure. So look, so we've now got, hopefully we've got all the Form E filled out and all the financials are there. So how is that settlement then agreed, and sort of how are the contributions from each partner taken into account once?
In terms of matrimonial settlement, typically we start, and I say typically we start because there's always variations. Typically we start since the year 2000, the case of White and White, that's like the landmark case, we have equality. So you get half each. In 1973, so 27 years before, we had the Matrimonial Causes Act, and Section 25 of the Matrimonial Causes Act sets out the factors that the court should take into account in deciding what the distribution of assets should be. So they used to look at these guidelines without the starting point of equality. Now we have a starting point of equality, unless there should not be equality. So what factors do the court take into account? I think I should just run through those briefly.
Yeah.
The first thing the court should have regard to is the welfare of any minor children of the family. So they're going to be looked at first. We then look at the income, the earning capacity, property, and any other financial resources that the parties have or are likely to have in the foreseeable future. So, for example, husband says he was been earning £150,000 a year. Now he's going to get divorced. I've lost my job. I'm only going to earn £25,000 in something less well paid because I don't want to give you loads of maintenance. Don't worry too much about that, because the court looks at earning capacity rather than income. And if he's just given up that job, he could probably replace and get that income level. So it's earning capacity rather than just income. But for our wives who are listening and watching, what's going to happen is the husbands are often going to expect you to get some earning capacity if you haven't already got that earning capacity. You can't always simply say, I'm going to stay at home. It might be the kids are so young and you can't work, but generally it's an expectation that you can get some form of income. We then look at financial needs, obligations, and responsibilities. If you are the primary carer, your needs are greater because you've got the primary responsibility of looking after the children and housing the children, which means you may need a departure from equality in your favor in order to provide for your housing. Mm-hmm. It may mean that you can't get the same mortgage because you haven't got the same mortgage capacity. So you may get more than 50% of the assets on that basis. We look at the standard of living enjoyed by the parties during the marriage. Now, realistically, most people are spending as much as they're earning or more, and therefore the standard of living can't be matched at post-divorce. So there's a real reality check. It's what you can only share what there is. You can't generate more than there is. And unfortunately, for many people, that's the reality of divorce. We look at the age of the parties and the length of the marriage. Now, if you just married a multi-millionaire and you've been married for 5 minutes or a minimum of a year before you can get divorced, it wouldn't necessarily be right that you have half of his assets. If it's a 20-year marriage or 15-year marriage and you've got 2 children and you've contributed everything together, I'll come on to contributions in a moment. The fact of the matter is the starting point should be equality. Age is relevant because you might be closer to retirement, you might be closer to taking a pension, or it might affect the number of years you can get on a mortgage. We look at the health of the parties. Are they both in good health? Because if you can't work because of ill health or it limits what you can do, that's a relevant factor. Contributions. The court looks at the contributions. Now, importantly, it's something I must emphasize for our wife listeners, and that is your contribution, looking after the home and bringing up the family, is considered by the courts as valuable as your husband's contribution if he's made a bigger financial contribution. So you start with parity. And equally, and I see so many very successful women who are incredibly peed off because they've worked and they've brought up the children and they've looked after the home, and they're having to share with their husband. I'm afraid that is the position, but it's hard to distinguish on the contributions. There are some exceptional cases where someone argues an unmatched contribution, or where inheritances come in, or the contribution is not part of the marital request, i.e. something that you've acquired together. Then people will say, well, he's had an affair, that means he should get less. It's his fault that the marriage has come to an end. Conduct is not really relevant. It's only relevant, and the words of the statute, if it would, in the opinion of the court, be inequitable to disregard. Plain speak, court's not really interested in how someone's behaved unless they've squandered loads of money, gambling, drugs, some other form of abuse, anything that's had a deliberate and willful impact on the finances of the family. Otherwise, they're not really interested in conduct. Litigation conduct is separate. And then the court looks at what benefit a party may lose, and that's pension. Pensions are really important. Don't disregard the value of a pension. That is, in effect, the factors that the court looks at. So start with equality, and then should we work away from. Now, a wife may, for example, need more than half the money in order to rehouse herself and the children, and therefore the court will give her more.
And are there any implications in terms of the law if the partner's moved country, for example?
Well, it depends then on jurisdiction. When you say they've moved country, that would be taken into account as all the circumstances of the case. Because if you move to a cheaper country, then your needs may be less. Mm-hmm. And I don't think it's going to be helpful to have a whole discussion about jurisdiction right now, because that's a topic in itself. Yeah. One of the things I should add, which I didn't mention, again, part of all the circumstances of the case, is prenuptial and postnuptial agreements. The court will take them into account. But in order to have a valid prenuptial or postnuptial agreement, postnuptial is one that's generated or created during the marriage. Both parties need to be independently advised. If it's before the marriage, ideally it should be not less than 28 days before the marriage. There should be financial disclosure, with each party disclosing what their assets are, so the parties know what they're giving up or protecting. And it should be in a document really drawn up by solicitors. Sure. Now, one of the things that people get worried about these days is parents who want to help their children make tax planning. If you're going to get lots of money from your parents, or they want to help you buy a home, they may require you to have a postnuptial agreement if you're already married, or you think your marriage is in difficulties, so that that asset doesn't become part of the matrimonial pot. Okay,
that makes sense. All right, well, look, I mean, we are running out of time, but it's been incredibly helpful. I do have, I'm just going to quickly look on the Facebook, because I've got another question if we've got time for it. I mean, so this lady's saying, what happens where there's been large imbalances within a marriage, i.e. substantially older husband has ploughed half the resources into ex-wife and kids and now is about to retire, and current wife has ploughed all resources into husband and their kids and facilitated him being able to support his ex. If they divorce while she's still earning, likely for years because she's a lot younger, and he's about to retire, is she going to have to support him and obviously his ex-family post-divorce? I mean, that's obviously quite personal and detailed, and there's obviously
that's a bit of a conundrum to finish on. But in short, the husband has the responsibility to his first wife and family under the terms of the existing agreement. The second wife doesn't have any obligation to fund the first wife, but if the husband is now retiring, then he's going to he's either going to invite his first wife to agree an adjustment or an end to the maintenance payments that he's making, or he's going to have to go back to the court to vary those payments because he can no longer afford to maintain her.
Yeah, that sounds like quite a complicated case, because obviously she's...
But the second wife shouldn't feel that she's going to be obliged or compelled or required to pay for the first wife, because that's not her responsibility.
Yeah, because she'll then probably be the only breadwinner as well. Okay, well, look, I mean, we could talk for hours. Look, if you could give us sort of some take-home tips for anyone currently going through a divorce today, or is thinking about it in terms of, you know, really what should be the first thing they should be thinking about now, just to, I suppose, release a bit of stress and get ready.
Okay, there are two parts of it. Firstly, do I want to end my marriage? Well, that's a massive decision. And so many factors are going to determine whether the marriage is at an end or not. But part of it is also the consequences, the financial consequences of getting divorced. And you have to weigh up, is the grass greener, or will your own lawn be greener still if you water it? You know, you have to think about where you want your investment to be, because some people just have had enough and they want out. And therefore, whatever the financial consequences are, then that's the right outcome for them, because they're going to be happier. Money isn't everything, although it's obviously very important for so many of us, but it's not everything. So happiness, think about carefully where you're at, but be prepared for the consequences. Before you make any decision, I think it's always good to get some advice, information gathering to help you process where you will be. Then once you're in the process, try not to make your decisions on the back of emotion. Try and be more clinical. Listen to the advice that you get. If your husband has had an affair and you want him to pay for that, and you want him to give you more money as a result, he won't necessarily, you might get it because he feels guilty about it and he feels that he should pay you extra, but you won't necessarily get extra money as a result. And when your solicitor tells you that, I know, because I have clients that find that really difficult to accept. Sometimes you need to listen to your lawyers. It's really sad because too much money is wasted on lost lot because people don't listen. If very quickly, I'll hold up that piece of paper, if you can see that, that's 100% of your assets. So if I go at one end and the other solicitor goes at the other end, that piece of paper is smaller and there's less to share. I think it's really important to listen to the advice and try and make rational decisions. And also, please bear in mind, you've got kids. The money that's available for you will also then eventually end up with them. But don't be bullied. If you've got a husband who's a bully or a narcissist or is really difficult, you need advice, you need protection. Another thing I should just mention, if you think, how am I going to pay for it? Talk to your solicitor, because they might be able to find ways about how you can pay for it. If you haven't got the cash immediately available to pay the bills as you go along, there are divorce loans that can be explained and be obtained. Sometimes family will help you fund it. As long as they're hard loans that are going to be repaid, that's not going to prejudice your position in the divorce, you can borrow it from family, or you can borrow it from specialist divorce lenders. But get advice, even if you can't afford to fund the whole process, get advice before you begin so that you can be more in control.
Yeah. All right, Neil, look, thank you so much. It really has been incredibly helpful, and we're recording this, and this will be shared in part of an article that you've written, which summarizes pretty much what we've been talking today, and we will embed the video there so people can watch it again and again and again. If anybody wants to contact you, Neil, where can they find you?
The best thing is my email address is on the handout that you're going to circulate.
Yeah, on our directory, yeah.
Yes, which is neil.russell@seddons.co.uk. That's the easiest way initially to reach me, and then we can have a phone call if needed, or a meeting. So yes,
and we'll share in the article, we'll share your contact details and the website.
Yeah. And my direct dial is on there as well. Okay,
perfect. All right, well, look, thank you very, very much indeed. Happy New Year to you. And sad as it is, it's an important conversation to be having. So thank you for helping us prepare anyone that may be going through this.
And thank you so much for having me on again. You do a wonderful job, fantastic help, and a group for ladies over 40 that need the support that you offer. It's an amazing thing, and I'm delighted to be involved with you guys. Thank you.
Thank you so much, Neil. Take care, and thanks everyone for watching. Have a good day.
Bye.
Bye. Bye.